that request is allowed, the applicants will have 15 days within which to file their written submissions and list of authorities. And similarly, the respondents will have 15 days within which to respond. And in the event that the applicants would like to file a response, they will still have 5 days to file the response. As regards the second request, that instead of filing 15 pages of written submissions, Senior Counsel Mr. Oraro, who was supported by Senior Counsel Honorable Martha Karua and Mr. Orwoch, asked for 30 pages, while Mr. Avi asked for 40 days. The direction we gave was pursuant to the Supreme Court directions contained under Rule 17, which gives directions on written submissions in the following manner. A, written submissions shall be in the following form. A, contained in one volume only, whose length shall be as follows. In appeals arising from the Court of Appeal decision, submissions shall not exceed 15 pages. And in matters where the Supreme Court has original jurisdiction, the submissions shall not exceed 30 pages. We have, however, considered that request against the context that the appeal before us is complex. It raises weighty issues which have generated immense public interest. We have also considered originally this petition was filed in the Supreme Court, but it was referred to the High Court and has now found its way to this court. And it is for those reasons, and further, that we have raised 7 issues that we think might require more space for explanation, that we have agreed that parties will be given 28 pages for the written submissions. And that will also mean that during the hearing, parties will be given 20 minutes to highlight the submissions, because there are very many parties in the appeal. Yes.
If it may please the court, manage the Chief Justice, the Deputy Chief Justice, and judges of the Supreme Court. We appreciate what the position of the court is, but in our humble view, this is such an important matter that is important for the public to be with the court, and therefore, I think it would be serving the court well and the public well if more time is allocated so that each party can articulate their case as best as they can, and the court can have an opportunity to raise as many issues as they wish. Otherwise, all the proceedings will be alien, and the public will only see the fact that there was a short hearing and a judgment and not understand why an interpretation may be made one way or the other on these very fundamental issues. I would therefore humbly request that at least the court identifies those main parties who are either on the petitioner side or on the respondent side, allocate them a little more time, and then the people supporting might be given reasonable time to present their cases. That's my humble request.
Thank you for that observation. The time allocation will be done on the day of the hearing, because then we will also have read the submissions to gauge the amount of time that each party should be given. I think that brings us to the end of the mention.